Now, unpacking the local government autonomy. The landmark Supreme Court decision in July 2024 granted financial autonomy to the local government authorities, but that decision has yet to be implemented. The court's decision was twofold. First, it held that the federal government of Nigeria must pay the federal allocations of the LGAs into their designated accounts, and that the LGAs should have control of their allocations. This decision was made based on the court's interpretation of Section 162, subsections 5 to 8 of the Constitution, which prescribed a joint state and local government account. The second decision of the court was on the legal requirement for democratically elected LGA officers, and the courts thereby abolished the governor's practice of having caretaker committees, by stating that only democratically elected local governments would merit the receipt of the federal allocations. The court's decision in July of this year, but up till date, it has not been enforced because of complicated constitutional issues that have trailed it. Now, I'm going to be looking at a few of them. Did the court engage in judicial legislating contrary to the principles of separation of powers? Did the court provide even an enforceable result? Why is it that some governors and some groups, particularly the governors of Anambra and Oyo states and the Afenifere Pan-Yoruba group, take exceptions to the judgment? Why did the federal government of Nigeria itself have to set up a committee to recommend implementation strategies for a decision that should just have been implemented? Why did the National Assembly also opine that they may have to legislate to bring the Apex Court's decision into efficacy? Do the local governments even understand what their functions are as prescribed in the 4th schedule of the Constitution? Or are they thinking that they are going to be independent or mini governors? Without the abolition or abrogation of the Section 7 and 162 of the Constitution, we have that point that the Constitution still recognizes state and local government accounts, joint state and local government accounts. Can the Supreme Court decision then be enforced against a governor like Soludo, who insists on the joint state local government account? How is the Constitution to be amended? Because all such amendments of a constitution can only be done with the acquiescence of at least 24 states, representing 2/3 of the states of Nigeria. It is very, very important to note that the Ninth Assembly, National Assembly in 2022 attempted to secure this same amendment to the Constitution, but they failed to secure the majority required of the states. Former President Buhari also tried to obtain similar results through an executive order, which the governors blocked. Now, it is time for us to just have a little bit of discussion on this. I know that you've had a lot of unpacking that has been done as regards the local government, but again, these issues have not yet been solved.